to get started here. So I want to just start off by just thanking everybody for coming. My name is Rick Martin. I'm an attorney here, Martin IP Solutions, which is part of Martin & Martin Attorneys at Law. A little background on me. I've practiced for several years in Boonville with my father. I specialize in intellectual property, have been working in that area for probably about 25 years in one way, shape, or form or the other, and opened an office here in Innovation Point on the 5th floor. I'm in Suite 503 earlier this year, and doing most of my intellectual property business out of this location now. In the process of updating some phone numbers and things, but I'll get the contact information at the end here. We're going to talk about, most of you in the room I know, some of you I don't. But the purpose of today's presentation is to talk about 7 things that every entrepreneur should know or needs to know when they're starting up a business, or even if you've already started your business, some things that you ought to know or should know about intellectual property. First item is your IP is a very valuable asset, and I think before you get too far into it, you need to identify it and you need to protect it. So the first things, oftentimes, if you have potential investors, the first question a potential investor is going to ask you most of the time is, do you have IP? What is it? And how is it protected? Do you have copyrights? Do you have patents? Do you have trademarks? What is the IP that you have of value, and have you taken the steps to protect it yet? Oftentimes, you're not going to get that investor to invest in your idea or your concept unless you've taken these steps ahead of time. One other issue here too, attempting to secure low-cost protection for your IP may result in inadequate protection or no protection at all. I'm going to show you a little video clip, I think, here from one of my favorite shows, Shark Tank, that kind of demonstrates that.
Next into the tank is Terracin Dupuy, who invented an eco-friendly must-have for babies.
Hi, my name is Terracin Dupuy, and I am founder and CEO of Fuzzy Buns Diapers. I am here asking for a $500,000 investment for a 15% equity stake
I love watching the
in my
expressions on
company.
their faces. So.
This trash represents the 1 ton of garbage that one baby generates in disposable diapers by the time they're potty trained. Disposable diapers make up the 3rd largest consumer item in landfills today. One disposable diaper takes up to 400 years to decompose. But sharks, I do have a solution. Fuzzy Buns are a 100% reusable diapering product that is easy to use and easy to wash at home. They save parents over $2,500 on their diapering cost because you only need 12 Fuzzy Buns in comparison to 8,000 disposables. They also keep babies drier, more comfortable, rash-free, which is why I created them for my own baby 12 years ago. So Fuzzy Buns are a pocket-style diaper. There's a pocket in the back that you insert a microfiber pad into. The lining is polar fleece, so even though the pad inside is wet, the lining is staying dry, so the baby's more comfortable and less diaper rash. The outside is waterproof, so everything stays where it belongs. Now, let's talk about the washing, because I know everybody wants to know, what do you do with the poop? So, it's easy. If it's solid poop, it just plops right on into the toilet, where it belongs, by the way.
It's never solid.
I'm getting there. If it's less than the ploppable variety, we have a handy-dandy diaper sprayer that attaches to a toilet. Parents can just rinse off whatever's left over. They put it in this mess-free hanging diaper pail. And then when they're ready to wash, you unzip the diapers into your washing machine, including the bag, and your hands stay clean.
Thank you.
Feeling these really makes you believe in them. The color of money for you.
looks like she's got a pretty good idea. She's developed it well. She's marketed it well. She's got
So,
trademarks.
who's ready to invest in fuzzy funds? Stop generating tons of trash and start generating tons of cash.
How long have you been doing it, Harrison?
12 years.
12? Wow.
12 years.
Wow. What are your sales last year?
Last year, there were 3.9 million.
Wow.
But I've sold $24 million worth with no advertising, word of mouth only.
Where are they sold?
Internet sites,
No retail?
no big box retail, but we have boutiques,
How much profit did you make on 3.9 million?
20,000.
Oh.
Why is it so low?
Because I have manufacturing problems. We went overseas into China, thought it was going to be a good thing until they took all of my product, patterns, etc., handed it over to somebody else. So now she's competing with me. I can't even tell the two products apart.
Kevin, are you paying attention to what she just said?
Hey, that's why you have a patent, my friend.
I have a patent, but it wasn't very strong. When I first started out, I had no money, couldn't afford a good patent attorney.
And your factory just gave this to her?
Yes, she was in Hong Kong. She was my distributor.
Wow, the story gets even worse.
I mean, you're in the poo-poo business, and poo-poo happens.
Yes, it does.
Did you sue?
We are suing.
Wow, you know, in my business, people always tell me you can sue anybody for anything, but good luck collecting.
Correct.
Right.
What do you think will happen to your sales if by magical force your patent's successful and you shut her down? What incremental sales would you get as a result of that?
70% more.
Wow. And you think your sales would go up 70%?
Oh, yes. Not just from her, from all of the people that are squatting.
Well, tell us more.
Whoa, sorry.
Who else is squatting?
Who else?
A lot of people.
If you combine them all and roll them up, how much do you think annual sales are?
I would say if I had to give a good average, probably selling between $30 and $40 million.
Whoa! Okay, hold on here. They're all breaching your patent?
Yes.
Now this is where poo-poo really happens. Because frankly, this is a very hard business. You've got to get retail, you've got to get distribution, you have inventory issues, manufacturing issues, or you work with my army of lawyers who sues everybody in the Stone Age until they agree to a license deal.
That is the slimiest, the nastiest, the worst element
Welcome
of
to the
business.
real world,
No,
Mark.
you look, if you're not part of the solution, you're part of the problem.
I am
That
the
is
solution.
absolutely part of the problem.
This is why we have patents. This is
You know
why we
what?
have
No,
law in
no,
this
no.
country.
You know what you do? You outcompete. Why have you not been able to just kick their butt because you're a better company, you're a better solution, and you're a better
And that's the
execution?
position I've taken this entire time.
Here's what I see. You hit a roadblock, and how you respond is exactly what guides your future. Unfortunately, it sounds like you talked to too many lawyers, talked to too many Kevins, and you were rudderless. And someone who's coming in is probably going to have to come in and do more pooper scooping, and I don't want to be in the pooper scooper business, so I'm out.
I'm looking at you and thinking of myself at different crossroads along the way where people stole my stuff, things got in the way, and I just had to persist, and I see that in you. What I'm not sure I trust in you is your judgment,
Okay, well, Barbara, if you invest in me, I will do whatever you tell me to do.
but I have no interest at all in being the entrepreneur for your business. I'm an investor, an advocate, but I'm certainly not going to solve all your problems.
I will not quit. And I see the vision for this company. I've had a lot of challenges from divorce to manufacturing issues to you name it. It's just not in my DNA to quit.
I'm sorry to say I am out.
Okay, thanks. Damon, I'm winking at you.
You know, when you first started talking all that poo, you attracted a really big fly over here.
Yeah.
But peeling back the layers on this onion is starting to stink, and I'm out.
Okay.
You seem to be looking for a lifeline. I like to invest in businesses that are in upswing. I think once a stone starts rolling down a hill, it's very, very difficult to stop. I'm out.
Tell me if any of the assumptions I'm going to make now are wrong. You're an innovator. You practically created the cloth diaper business.
I did.
But yet at the same time, everybody else took a huge part of it, 70% of it away from you. Some of that's your fault. It just is.
I started this industry. I grew it. I did all of the footwork.
Look, I admire your tenacity, but I don't want to join you on your ride. I wish you the best of luck, but I'm not.
Okay. Thank you.
Good luck.
Thank you. I didn't get a deal from the Sharks, but I'm not upset with them. They told me the truth, and they didn't do it from a good business perspective. But you know what stopped me from getting a deal? All of the IP squatters out there that are making tons of money off of my idea. So, just look out.
Okay, so I would tell you that I think the problem she has here is not, I think she referred to it as a manufacturing problem. But listen to what else she said early on in the process there. Early on, she couldn't afford to hire, she didn't have the money, she couldn't afford to hire a patent attorney to do the job right, so she skimped early on, and she went to secure low-cost protection for her invention, and look at the millions of dollars that she left on the table by doing that. 70% of the market is being taken up by other people. I can't tell you that I've looked into this in detail, but I suspect she talks about patent squatters. She talks about people that are, and I think she used the term breaching. I think I would use the term infringing her patent, and she's in the process of suing them. I suspect that the situation is because she has a weak patent. They're not infringing her patent, but they found ways to get around her patent. And that's why it's so important to not skimp on low-cost protection on the front end and leave millions of dollars on the table like she's done here. $30 to $40 million a year that other people are taking, and she's making $20,000 off of her idea because she chose to cut corners on the front end. If you've got an idea and it's worth protecting, make the investment up front and protect that idea. Again, you need to focus on value rather than the cost, and I think this was a good example of value rather than the cost. You know, the value of properly protecting this idea was millions, tens of millions of dollars. You know, the cost, you know, tens of thousands of dollars to protect it on the front end. So oftentimes it's worth the cost when you look at it from a value standpoint. Also, in developing your business plan, particularly if you have something that's centered around technology, you want to make sure that you include adequate funding in your budget to invest in an IP portfolio. So we've talked about IP, IP and an IP portfolio. Let's look at the different types of IP and it's important early on to identify what is your IP and how can it be best protected. And again, the details around your product or service, once you sit down and talk with somebody that's knowledgeable in the area of IP, they can listen to you, understand what your business is, what your product is, what your service is, and identify what types of IP protection may be best for you. Again, most startup companies and even ongoing businesses, if they haven't done so already, should consider more than one form of IP protection. Oftentimes, even if you don't have a technology-based business that would lend itself well to patents, some of the other IP protections would benefit you. And again, there are four main forms of IP protection. So we've got patents, trademarks, copyrights, and trade secrets. And I'll talk a little bit about what each of those cover and how those might be of benefit. So, patents. What a patent does is it's essentially a limited monopoly. At least in the United States Patent and Trademark Office is the government mechanism or the government agency that handles the granting and issuance of patents. The term of a patent, once it issues, is 20 years from the date that the patent application was first filed. And what it does is it confers or it gives you as the inventor or owner of the patent the right to exclude all others from making, using, offering for sale, selling, or importing your invention. I think equally important is what it does not do. It does not grant you as the inventor the right to make, use, sell, offer for sale, or import your own invention. And I'll give a brief example here. Let's say I own the patent, or I developed the patent on the combination of A and B. And I've gone out and I took elements A and B, I put them together. Wow, this is great, this works very well. I get a patent on it. So I hold the patent on A and B. So I have the right to exclude everyone else from making, using, offering for sale, selling, or importing the combination of A and B. So let's then say Steve here, Steve looks at that A and B and he says, okay, well gosh, if I add C to that, I get some just amazing results that I really wouldn't have expected, and it's better. So Steve goes out, he applies for and gets a patent on the combination of A, B, and C. So Steve now has the right to exclude all others, even me, from making, using, offering for sale, selling, or importing A, B, and C. But Steve does not have the right to make, use, offer for sale, sell, or import A, B, and C, because A, B, and C also have A and B in it. I hold the patent on A and B. So that's, I think, a good example of what it gives you the right to do, what it doesn't give you the right to do. So just because you have a patent on something doesn't mean that you don't infringe on somebody else's rights, and vice versa. Just, you don't have to have a patent on something to move forward with your idea or invention. A lot of people, if there's things that are in the public domain, or otherwise, you can still move forward with a business model without a patent if it's in the public domain and nobody else has rights that you would be infringing upon. And in that type of case, you probably want to look at other forms of intellectual property protection to kind of secure your business model. Trademarks and service marks. What trademarks and service, a trademark is a word, name, symbol, or device used in trade with goods or services. And what it does is it identifies a particular product or service with the source of that product or service. So in trademarks, they can be symbols, they can be words, names, devices, even colors, even sounds. I give a couple of examples of the Nike swoosh as far as a symbol, the golden arches. Those are all things that you look at and you know who provides the products or services that come along with that particular item that you're buying, and you recognize or expect a certain quality of that product or a certain something tangible with it. Colors, Owens Corning pink fiberglass insulation. Nobody, they have trademarked the pink color for fiberglass insulation, so they've got that. Harley Davidson has trademarked the sound that goes with that their motorcycles produce. So there are things other than words, names, and symbols that can be trademarked. Again, it may be used. What a trademark then is used for is to prevent others from using your trademarked name, symbol, or something that's would be called confusingly similar. And the idea there is, you've developed a brand around your product, around your business, and that in and of itself is protectable. And it's not okay for somebody else to essentially play off of that brand and to make money off of that by using either the same branding or something that's very similar to sell a product or service that's very similar to yours, to where people are confused as to what the source of that product may be. So, I mean, the likelihood of confusion, and again, that's sort of the legal test there in the trademark realm, is would there be a likelihood of confusion if I go to buy this product that maybe I think it's coming from somewhere that it isn't. So that's kind of what you're looking at in the trademark field. Copyrights, and copyrights are things, protection that's provided for original works of authorship. And those include things in the literature realm, dramas, you go books, screenplays, stories, music. Music is probably one of the more enforced areas of copyright. Art, painting, sculpture, etc. Software is probably another area that is sort of a very prevalent area that copyright law is applicable to these days. What it does is it protects the form of the expression, not the idea or subject matter. So I'm going to use software for an example. What software would protect, essentially, a copyright on software is going to protect your source code. It's not going to protect what the software actually does. Again, copyright law protects copying. So if you have developed a software program and I come along and I basically copy the source code and then, or parts of the source code for various reasons to come up with something that's similar, that is an infringing activity. However, if you have software, I look at it and I think, well, that's kind of cool. I like that it does this. I like that it does that. I sit down and completely independent of your code or anything else, I draft my own code for a software program that essentially does the same thing, not infringement. So again, it's, it boils down to copying, not is it the same in the realm of copyrights. Patent, it doesn't matter. If it's the same, it's the same, there's infringement. Copyright, it really looks at what is the activity involved, and is it something that you've done to copy the work of someone else. Last, trade secrets. And trade secrets are really any, and I think this is one that is applicable to really any business that I could think of. Every business, whether they know it or not, I think has some trade secrets, because that's valuable commercial information that provides you with an advantage over your competitors. And at least any business worth having is going to have some trade secret information. They're going to have certain things that they want to keep, to themselves and not have their competitors know about. Some examples, if you have manufacturing processes, customer lists, that's probably one that every business has. If your competitors had your customer lists, if they had your notes about your customers, if they had your information about your customers, what they like, what they don't like, those are all things that help you service that customer better than the next guy could. And if your competitor had that list, then they could effectively compete with you better than they can otherwise. Two things to qualify as a trade secret, essentially. One, it must be not generally known to the public. And the second is you must take some kind of efforts to maintain the secrecy of that information. Oftentimes in small startup companies, if it's just you, just a couple of employees, when you get to employees, if it's just you, that's just not telling anybody, keeping it secret, holding it close to the vest. If it's certain information, keeping it locked away, basically you not disclosing it. The more people you bring into your organization, the more steps you have to take to make sure that that information is protected and maintained in secrecy. So a lot of times you'll have employee agreements with your employees, non-disclosure agreements, non-compete agreements, things of that nature that are going to protect your company from somebody that you bring in to work for you, that you disclose this information to help grow your business. These types of agreements protect you as the developer and owner of the trade secret information from them leaving your company and going somewhere else and competing against you using your information that you've spent your hard-earned time and money to develop. Another issue, you want to secure your protection, whether it's patents, trademarks, not necessarily in trademarks, but primarily patents, trade secrets, before you disclose your ideas to others. There are reasons for trademarks as well, but probably to a lesser degree. And from a patent perspective, one main reason to do this in the patent area is the U.S. in 2012 went to what's called a first-to-file patent system. Before that, we were a first-to-invent system. And the main differences there, I still get this question all the time from people about patents. They'll say, well, I'm protected. I wrote down my idea on a piece of paper, I put it in an envelope, and I mailed it to myself. So I'm protected, right? And protected, there are degrees of protection. Under the first-to-invent system, that did provide you some protection, because if we ever got to a point of trying to figure out, it was truly based on who invented it first. So if you got into a dispute with somebody else that has the same invention as you, it would come down to, okay, who can document when they came up with this idea, and who can document I invented it first. And that was good evidence of invention there to say, okay, I've got this envelope with a postmark on it, and this is inside it, and so this establishes that as of at least this date, I had come up with this invention. Totally worthless now. Totally worthless because we are on a first to file. So it is now, since September of 2012, a race, literally a race to the patent office in most cases. So, you know, if you come up with the idea and somebody else beats you to the patent office, under most circumstances, unless they truly stole it from you and didn't invent it, they're going to get the patent, not you. I recommend typically whenever possible, before disclosing your idea, before demonstrating it, before pitching it, before any type of disclosure, that you file a provisional patent application. What a provisional patent application is essentially it's a placeholder. It gives you patent pending status, and it gives you a date certain that your application was filed on, so it avoids some negative implications, which I'll get to later in the presentation, about disclosing, or about disclosure before protection. And again, you know, wow, get to it sooner than I remembered. So disclosure in most foreign countries, you know, if I say I'm here and instead of doing this presentation, I'm doing a presentation on my invention or my idea. You know, it's arguably for commercial purposes, so that would be a public disclosure of my idea. In most foreign countries, if I file my patent application tomorrow, I've waited too long. You know, I disclosed it today. That's prior art to, you know, my application, so it's a bar. I cannot get a patent. The U.S. still has a grace period. I believe it's a 1-year grace period that's applicable in most situations. So you potentially could still get protection in the U.S., but you're going to forfeit it in most foreign countries if you disclose before you file. And again, I recommend at least at a bare minimum. If you can't, and this would be in a limited or smaller disclosure setting. If it's on a one-on-one basis, not a sale, this certainly would not apply to a sale of your product. It would not apply to a public presentation of your product. But if you're in a situation where, say, you're going to talk to investors individually, one-on-one, or you're going to talk to a company about manufacturing or things like that, and you either aren't ready to or haven't secured the funding yet to file your provisional application, at a bare minimum you get a confidentiality and non-disclosure agreement from that person that you're disclosing to prior to disclosing it, and that should give you some limited protection from the pitfalls here that we see. The next item, who owns the IP? And that can be a tricky situation, particularly if you have multiple inventors or multiple entities involved in the process. IP is originally owned by the inventor or creator. And when I say inventor or creator, I'm really referring primarily to copyright and patent law there, the inventor in the patent realm, the creator in the copyright realm. So whoever invented or whoever created the particular product is originally the owner. Like I said, that's a little problematic when you have, in a lot of patent settings, you'll have multiple inventors. You'll have 2, 3, 4, sometimes more people that collaborate on a project and are all inventors. One of the issues or problems you get into with that, and I've had this with some clients in the past, one issue I've had in the past is this guy will file his patent application and this guy will file his patent application thinking I did this on my own. That's obviously, if you work together, it needs to be filed together in a joint process, but those things happen from time to time and can't be helped. But essentially, even where you have multiple inventors listed on the same patent, each of them have the right to make, use, and sell, or to prevent others from making, using, selling. I caught myself there. From preventing others from making, using, selling, importing, They also have the right, each of them individually, to license those rights to others. So you get into a situation, if you don't think ahead, if there's a situation where you've come up with something with someone else and there's multiple inventors, you can get into a situation where Steve's licensing to this guy, and I'm licensing to that guy, and Rob's over here and he's an inventor and he's licensing to somebody else, and it really dilutes the protection that you have. So that's certainly something, if you have multiple people involved, you want to kind of work together and try and come up with something. I'll get to, again, joint ownership, so that's mostly what I've talked about there. In that type of setting, what I typically recommend people form a company, an LLC or whatever corporate form your tax professional thinks is advisable. Form a company, and then there must be, in order for the company then to own the rights to the invention, each of the inventors must then sign a document or assign their rights to the company. And I recommend doing that, particularly in a situation where there's joint inventors. Do that early on. Don't wait until later, because you wait till later and things happen. People have different ideas, go different directions, and that may not happen. So I would suggest doing that early on. I make a practice typically in that situation with clients to get that assigned to paperwork done on the front end, usually before we file the application, so that we've got that straightened out before we ever get that far. Employee agreements, and I think that's where one of the other, where we talked about trade secrets, another area to address in employment agreements that involves IP is who owns it. So, if I work for XYZ company, typically there's going to be a clause in my contract that says, and there are varying degrees of this clause, but typically if I develop something in the course of my employment at that company, I don't own it, the company does. If I'm using company time, if I'm using company resources, they may have an ownership interest in that. It's advisable, I think, in all situations to have an agreement with your employees that specifically defines who owns what and under what circumstances. Absent an agreement, you could make an argument. I mean, if I have no employment agreement, let's say with XYZ company, but I'm using their computer to work on my project, on my idea that ultimately results in a patent. Arguably, they may have some claim to that, because if I was doing it on company time, using company resources, that's where you get into situations where litigation happens. If you have a good, strong agreement that anticipates those, it's less likely that you're going to get into that type of situation. Copyrights and works for hire, and that's sort of a similar situation where, if I commission somebody to create a sculpture or a painting, or hire somebody to say, okay, I need some software that does this, this, and this, but I have no idea how to write software. Here, I'm going to hire you to come in and do that for me. Those are typically what are called works for hire, and typically by law, the person that commissioned it or paid for it is the owner, but again, it benefits to have an agreement, which brings me to the last point. Always get it in writing. That's what you want to do in any of these situations. If it is a work for hire, have a written agreement with this person that you've hired to do that, specifying that it is a work for hire, so that there is no confusion and that there's no problem down the road. And I've touched on this in a couple areas, but in this economy and in this day and age, I think everybody needs to think global. IP protection typically is territorially limited. So if I secure patent rights in the United States, it's limited to the United States. If your company does business in other countries, you need to seek and secure protection in those other countries. Same with trademarks, same with copyright, same with other forms of IP. That's the situation. Again, it's afforded on a country-by-country basis for the most part, and I'll get into some ways around that. So what I would suggest is, early on when you're securing the protection, identify, the foreign markets for your product or service. Are they out there? Are you already in those markets? If not, is there potential in other markets? And take a look at that. Again, overseas manufacturing is another. I mean, if you're limited to just the U.S. for your product, it may not be necessary, even though, you could have the issue of overseas manufacturing. So let's say China, for example, that may not be a good example because their IP protection is, there's very little teeth to it or very little enforcement. But, let's say you secured patents in China, theoretically they would actually enforce them. You could stop someone from going to China and manufacturing your product. But let's assume for a minute that you don't have a patent in China. A competitor, I don't know if it's Hong Kong, China, or where the Shark Tank video she mentioned, somewhere overseas where she took this for manufacturing and they essentially stole it from her. If you have a U.S. patent, they still cannot import that here. They can't sell it here. So the manufacturing just deals with the making part of it. If you don't have foreign patents, but your market is primarily in the U.S., there are other mechanisms to prohibit somebody from bringing it into this country, even though they can make it in China or make it wherever they want. So primarily, it's good to secure patents in places where manufacturing may take place, but I think primarily, and even more important, you got to look at where your customers are and where your market is. That's where the primary patents need to be filed. There's a process, something called a PCT, or an international application, which is it's a cost savings or cost deferring mechanism, depending on how you wish to look at it. But it essentially gives you the time that you need when you're in the patent process to sort of analyze and decide where your markets are. And what the PCT, or international application, does is it allows you up to 30 months from your priority date or your first date of filing to defer entering into foreign countries for filing patents. There's some other benefits to it, but that's the primary benefit there with a PCT application. So if you file a U.S. application today, typically without this mechanism, you've got 12 months from now to file in foreign countries, or you lose your ability or your rights to do that. What this does is it extends that from 12 months all the way up to 30 months in most situations. Beware of the IP of others. And again, I think we've touched on this with the example I gave earlier. Just because you have a patent on something or just because you have a product doesn't mean you can manufacture it. So what I work through with a lot of my clients that I deal with, and I said this is probably as important, if not more important, than securing your own protection for IP, because what this does is this says, okay, you need to even consider this before you consider securing your own IP protection in a lot of areas, because do I even have the freedom to operate in this area or this niche of the market that I want to operate in? The first thing to do is to identify who are the players in your market, who's the competition, who's out there, who's doing this, and then do they have IP? You can do a search or hire someone to do a search, and there are various ways to determine whether they have IP. It's not too difficult to do some searches, find out, do they have patents, do they have trademarks, do they have copyrights, do they have something out there. Trade secrets probably not really easy to determine, but the other three, that they're going to be registered and licensed with Copyright Office, the Trademark Office, the Patent Office. You can do searches to see what IP they have. Then the next step is to conduct an initial IP review, and that can be done on varying levels to really do a 30,000-foot look at their IP once you've identified what they have, and say, okay, is this even in the ballpark of what I'm trying to do, or is this something that's so different that I don't need to really focus on it too much? And then obviously the next step is, if necessary, if you look at that IP and you identify identify some potential, problem areas, drill deeper. Freedom to operate opinions, non-infringement opinions, and those are variations of the same thing. But that's sort of looking at their patents on a much deeper level and saying, okay, is what I'm doing infringing their claims, or what do I need to do to navigate around these patent claims? Invalidity is another way in looking at that too. A patent, when it issues, is presumed to be valid. But the patent office makes mistakes. Let's be honest. They've made a lot of mistakes over the years and issued a lot of patents that shouldn't have issued because, quite frankly, they may not have had all of the information at their fingertips when they considered the granting of that patent. So if you have information, if you have prior art that you're aware of that may not have been considered by the patent office when the patent was applied for, obtaining an opinion from an attorney that, if this, had been considered, the claims would in all probability not have been issued, is also another mechanism to kind of get yourself around your competitor's IP that may be out there. Lastly here, I think if you're starting up a business, or if you're in the early stages of a business, or if you are further down the road and haven't done it yet, I think everybody needs to develop and implement a comprehensive IP strategy. Part of that is, you're going to use your budget that we talked about earlier, and you want to get with your attorney, conduct a critical review, evaluate what investment in IP is going to give you the biggest return on your investment there. It may be patents in some certain situations. It may be trademarks. It may be copyright. It may be just preserving your trade secrets, drafting employee agreements, doing various things to make sure that what you have is covered and is protected. And again, some of those, you got to do the value versus cost analysis. Some of those things are low cost and easy to do. Some of those things are higher cost, but again, usually the higher cost ones are going to return a lot more value. And again, you need to consider all forms of IP: patents, trademarks, copyrights, trade secrets. Once you sit down, conduct that review, we can identify what forms of IP may be best suited for you. And again, I think so all of these, this is kind of a review here, so you want to initially look at the protection, but again, the freedom to operate, what do your competitors have, what IP is out there that you need to navigate around. Those are obviously things that need to be considered, and not only initially, but on an ongoing basis. I've got a couple clients that I do periodic reviews for, where I will track and monitor what their competitors are doing. When their competitors get patents issued, we sit down and we take a look at those. So, just doing this at one particular time isn't necessarily enough, because your competitors are out there and they're active and they're innovating and they're developing and they're patenting things all the time. So you need to kind of continually keep an eye out for what they're doing and keep yourself out of trouble. And again, once you acquire patent protection or trademark protection or copyright protection, there's a duty to enforce your rights, or those rights may be stripped or taken away from you if you allow others to continue to infringe your patent and you don't enforce that. If you allow others to use your name, use your logo, use your trademark, that devalues that product and or that trademark or that patent to the point sometimes where a court may determine that you no longer have any protection because you failed to enforce your rights. And again, at that point, you've invested the money to get those rights and to exclude others from using your name, your invention, your IP. It only makes sense that if you spent the money on the front end, the value in it, the value that you invested comes at the enforcement stage. Again, there's a cost to enforcement as well, but the value is $20, $30 million a year instead of $20,000 in profits. The profit margin that she had, I think, was $20,000 on $3.8 million in sales. And on top of that, she said there were $30 to $40 million, I think was the figure, of other sales out there that she was losing out on because of a weak patent. So, you know, that is part of the IP strategy, and I would encourage everybody, think about that, get on that early rather than later, because, you know, if you wait until it's too late, like the woman from the Shark Tank there, you may have already missed out on